Okay, thank you. And as promised, I wanted to thank Loretta Williams for coming and talking. This is her second year in doing this. It's been very valuable, and I know that every time I listen to a lawyer, Loretta, talk about the legal issues of Alzheimer's, I know that I learn something every time that happens. So I want to thank her very much for doing that, and I will turn it over to Loretta. And by the way, Loretta, is it okay if we send out your legal information to the group after we're finished?
So as Bill said, I'm Loretta Morris Williams. I'm an attorney in Fairfax, Virginia. I've been working in elder law, estate planning, guardianship, special needs areas for about 20 years. And I really appreciate the opportunity to talk with you folks today. I always like it when people are interested in knowing what their legal documents do. And I do thank you very much for your patience as we get this presentation going. So let's go ahead and get started. Like any attorney, I'm going to start off with a good disclaimer. Obviously, information in this session is for background purposes only. It's not legal advice and does not establish an attorney-client relationship. So what I wanted to do today is talk about a few different topics. The planning tools that are useful when you're assisting somebody who's got Alzheimer's or another dementia, and that are also important for yourself. So we'll talk about durable general powers of attorney, medical or healthcare powers of attorney, advanced directives, wills, trusts, and then a few things that are useful to know about Medicaid, because I know that's always an important topic for people who are dealing with long-term care issues. So here are some tips for doing your legal planning. First preference in planning is to start early, which very few people do. So if we haven't started early in doing the planning, then we should start now. I do recommend that if you're dealing with issues involving somebody with a progressive disease or anybody who's concerned about disability while aging and need for long-term care, working with an elder law attorney. That designation, CELA, C-E-L-A, behind attorney's name means that that person is certified in elder law. It's done by a national foundation, and it involves taking an exam that's pretty much like a one-day bar exam, plus having a certain number of years of experience, case experience, 15 credits a year of continuing legal education in elder law. So when I'm looking to refer a client to an attorney in another state, if there's not somebody I know personally, I'll steer them towards a CELA. Oftentimes when you start working with an attorney, they're going to send you a questionnaire. We're not really just nosy. The reason we have a questionnaire is that if the information comes back to us in that format, we can quickly and efficiently assimilate the information. And if I review a questionnaire, it can save you 20 minutes of consultation time, and we know that that gets to be expensive. Always be sure to share your top priorities or concerns, and it's good if you can prioritize them to make sure that, if you're having a 1-hour meeting, that your top 2 or 3 priorities or concerns are addressed. And a lot of clients find it helpful to write down their questions or even email them before the consultation, so that we can try to be sure to answer them and get everything covered. A lot of times we're trying to fit a lot into an hour or not too much more, which can be tricky. So on to the actual tools. The first one I wanted to talk about is a durable general power of attorney. You all may have experience with this as caregivers. I hope you do. This is the document you use to manage somebody else's financial affairs or to give somebody authority to manage yours. So, and I'm just going to most likely refer to this as a power of attorney or a financial power of attorney. We have bad habits as lawyers of using different words for the same thing, so I'll try to stay consistent. What the durable general power of attorney does is delegates authority to manage financial affairs. It's an essential component of the estate plan. A lot of people will think, oh my gosh, I need a will. They come in, they're concerned about their will, or does mom or dad have a will, which is important. But making sure we can care for each other during lifetime is even more important. And a power of attorney, when it's created, is a revocable document. So sometimes when you read these and you see all the powers you're giving to somebody, you're like, oh my, this is a little scary, but whatever we do can be undone or changed. It's not set in stone. So here are the people who are the players or the parties in a financial power of attorney. We've got the principal. So that's the person who signs the power of attorney and the one who's delegating authority to another person. The person who's going to do the work is called the agent. They act on behalf of the principal and their fiduciary for the principal. So if I'm going to do a power of attorney and I'm going to have Bill as my person to take care of things, I'm the principal. Bill is the agent, and he would be acting for me, not over me. He doesn't get to, it's not taking away any of my authority, but it's giving him the ability to help me. One of the things that's particularly important when we're dealing with people who may have some diminished capacity is that there is a legal standard of capacity to be able to do a financial power of attorney. And that's the capacity to enter into a contract. So sometimes we have clients who come in and the person that they're caring for is too far along in their disease. They have, their capacity is diminished too much that we can no longer do a power of attorney. So we really want to get those done before we have any kind of diagnosis. And if not, if somebody's receives a diagnosis and they're early in the progression of the disease, we want to make a priority on getting these documents done. So when we create a financial power of attorney, we have two choices for our effective date. The one most clients will do is to make it effective immediately when it's signed. So what that means, if I do a financial power of attorney, I'm naming Bill as my agent. When I sign that document, he can go into the bank 10 minutes later and use it to get access to my bank accounts. Oftentimes, we don't actually want the person to act right away. So usually what we do is we tell them, you know, hey, Bill, you're my agent under my power of attorney. I'm going to be keeping it in my home safe. I'm going to mail you the combination so you can get into it. If something happens to me, please go into the house and get that out and start using it. The other alternative is called a springing power of attorney. And what that means is it springs into effect when certain conditions are met. And usually those conditions are having statements from two physicians certifying that the principal can no longer manage their affairs. So in that scenario, and Phil, I'm going to just pick on you throughout, if I become unable to manage things before Bill can get into my accounts to pay the bills, he's going to have to track down two physicians or healthcare professionals as defined in the document and get them to say, no, she can no longer manage for herself. That can be a little bit tricky to do. It's easier if somebody's in a healthcare setting, but particularly with dementia, when sometimes you have people, you know, usually we're caring for our loved ones or often at home. The disease is not necessarily a straight line. So you have somebody who's doing some things and not others. It can be hard to get those certifications. So a lot of times the powers of attorney are done so that they're effective immediately upon signing. And then the power of attorney you'll typically see some magic words in there that say this document or this authority survives the incapacity of the principal. State laws are starting to catch up to say that a power of attorney is durable unless it says otherwise. But originally, because the power of attorney is essentially a contract, decades ago, the document would become ineffective if the principal no longer had capacity to make their own decisions, which made the document pretty useless. So you'll often see those magic words that survives the incapacity of the principal. So what can we do with the power of attorney? What's the scope of that? If it's a general power of attorney, then the agent usually can do just about anything that the principal can do. And some of the, it's going to depend on what the power of attorney says, and also the state law it's written under. In some states, the statutes say that there are hot powers, which is colloquial, not the official term. And these are things that unless the power of attorney says you have the authority to do them, you don't have that power. And a lot of these hot powers are things that we need if we're doing any kind of long-term care planning, particularly we have somebody who may need Medicaid at some point in time. So they include things like being able to make gifts in unlimited amounts, being able to create a trust for the principal, perhaps some delegations or substitutions of the agent. So it's important to have a power of attorney that is well drafted and is drafted with knowledge of the state law where you're operating. Because sometimes things I've seen, gifting provisions that clients bring in when we're doing planning for long-term care, but they didn't specify that it's unlimited gifting, therefore it's limited to no more than $16,000 a year, and that's not necessarily useful for Medicaid planning. Sometimes powers of attorney are intentionally limited. They're created for just a specific purpose. It used to be a very frequent one that they'd be limited for sale of real property. That's still a thing that you can do a limited power of attorney for, but because a lot of sales are being done with people signing through DocuSign, there's less practical need for it. You can have, I've had clients where we've done limited powers of attorney just for specific assets. When there was a particular reason that somebody needed to deal with that asset, not something else. You might do a limited power of attorney to one person to handle my digital assets, but have somebody else handle my more traditional assets. And so if you are named the agent in a power of attorney, which is very likely if you're caring for a loved one, there are some things that you need to be careful about doing. The first thing is, if you're the agent, you want to make sure that when you're signing something, you're doing it in what's called a fiduciary capacity. You're doing it not individually, but on behalf of the other person. So we have the example here, if John Doe gives his power of attorney to Jane Doe, she's going to sign John Doe. She's going to sign his name, but she can't stop there, because if she just signs his name, that's forgery, and we don't want to do that. So she's going to put, she's going to by Jane Doe to indicate she's the signer. And then she needs to write agent over after that to indicate what capacity she has to sign for John Doe. In Virginia, I recommend that the agent keep third-party records. Those are basically the bank statements or financial statements on the accounts that you're managing, and receipts, particularly for any reimbursements. Because under our state law, an agent under power of attorney can be asked to account for their actions for up to the 5 previous years. And that request can come up to a year after the death of the person you're assisting. So I suggest my clients to keep, they can be scanned and kept electronically, but to keep 6 years of records, not just our notes, so those are helpful, but we actually want the bank statements and receipts that we've dealt with. Power of attorney terminates when the principal dies. So if I give Bill my name him my agent under power of attorney, when I die, he can't use that document anymore. And then the final question is one that the attorneys can't really help with very much, and that's being sure to choose your agent carefully and the person best suited to the job. Sometimes clients will name children logically as the people who are managing their affairs. And sometimes they'll do the oldest child and kind of go in that order. And we need to think to ourselves, is the person we're naming, is this a suitable job to give them? We don't want to burden one person too much, but in sharing jobs, we want to make sure that we match it with the right, we put the right person in charge of the job. If we have somebody who's got trouble managing their own money, somebody who borrows a lot from mom and dad, somebody who can't keep records, then you want to think about whether or not they're the appropriate person to manage your money, particularly at a time when you can't oversee what they're doing. So that was a lot of information on the durable general powers of attorney. I will take a breath and a sip of water, and let's see if we have any questions at this point.
I don't see anything in the chat. So not yet, at least.
Okay.
Okay. So
Is there-
no questions yet.
Okay.
Yeah, let me make one comment. When I placed Nora, what I did was open a specific bank account, which I funneled all her expenses through, so that when it came time to do the annual reporting to the state, all I had to do was look at that one account. I didn't have to filter out all of the transactions from other places, and I didn't want to commingle the money that I was using to pay for her care on that. And that would be, to me, a recommendation would be that if you're in that situation, to open an account specifically for paying for those transactions, and you can use those statements of that account to put your report together.
Right. So with the power of attorney, we're not necessarily reporting to anybody unless somebody makes a request or within the family it's decided to do that. But absolutely using, a lot of times you're just using the person's checking account, but having everything go in and out of that account, you're absolutely right. It makes keeping track of it much, much easier, and absolutely not commingling with other funds, especially your personal funds. I can see that Susan's got her hand up.
Yes, and also there is a question in the chat, if you don't mind answering that. What happens if the agent becomes incapacitated? And if you could speak up a little bit, they're still having trouble hearing.
Okay. So sorry, we're with the other, since we're, yes, I'll try to be louder. So if the agent becomes incapacitated, our preference when we prepare the documents is to have an agent and at least one successor agent. So at least one backup. So that if the first agent, and there are provisions, at least in our powers of attorney, about how to remove an agent, which basically does involve getting the doctor's letters that they can't act if they don't have the ability to resign. But when we set up the power of attorney, absolutely, if we can have at least one successor agent, that's good. If something happens to the agent while the principal is still fine, then we update the power of attorney. So if I've named my spouse as my agent under power of attorney, and then I've got my son and then my daughter, something happens to spouse, I'm going to update my power of attorney to just go to son and daughter. So yes, that's a very good question.
Okay, Susan, go ahead, unmute yourself.
Yes, I'm pretty sure this is durable power of attorney, but it doesn't state it on the power of attorney I have with my mom as being her agent. It says, this power of attorney shall not be affected by my subsequent incapacity unless I have stated otherwise below under modifications.
Okay, so if there's nothing, that would sound like unless there's something that follows that, that's kind of it was kind of those magic words, except they left a, it says it doesn't terminate for disability, or you can have a power of attorney that terminates under specific conditions.
This one under modifications, under that section, there isn't anything. So
if, as I said, unless under Virginia law, unless the power of attorney has conditions it terminates under, or, unless it says it terminates under some condition, it does not terminate just through time. It doesn't become stale. It only terminates by death of the principal or termination, revocation by the person who set it up. Revocation.
okay. Yeah, this is in New York, but so that makes it durable then.
So I can't opine on what your New York power of attorney does, or even your Virginia one in this kind of setting. It sounds like it does, you can read what's on the face of it, but you'd need to ask the New York attorney if you have specific questions.
I see. Okay, thank you.
Sure.
There is one more question. Can someone with mild Alzheimer's draw up a power of attorney? And before you answer, I would remind everybody that the subtitles are activated so you can read if you have trouble hearing Loretta. Go ahead, Loretta. So can someone with mild Alzheimer's draw up a power of attorney?
So the ultimate answer to that is it's going to be the discretion of the attorney who's meeting with them, if they feel like ethically this person is understanding what they're doing. The standard is to be able to enter into a contract, but typically people with mild Alzheimer's still can, but ultimately what happens when we prepare documents for somebody, we have to be sure that on that given date that they're going to sign, they're understanding what they're entering into. So I would expect so, but your mileage could vary.
Okay, thank you.
Okay. Anything else on durable general powers of attorney? And if not, we'll move on to healthcare decisions.
Okay.
Okay. Okay, so the other set of documents that you may hopefully be working with already. This one can go by a lot of names. It's the same principle. We typically talk about a medical or healthcare power of attorney. Like the financial power of attorney, we've got a principal who's naming an agent, but this time they're naming them to make healthcare related decisions. You might also see documents that are called a living will or a natural death declaration. Depending on the state and the attorney you're working with, the living will may be part of the medical power of attorney, or it might be a separate document. Living will and natural death declaration are pretty much the same thing. Medical or healthcare power of attorney are pretty much the same thing. Whether they're in one document or two is going to vary by state and by practitioner. The other piece of, or one of the other pieces of the healthcare decision making is the advanced medical directive, sometimes called a healthcare directive. And that's where people get specific about what care they want or don't want. that's not necessarily life and death related care. So the living will says what I want or don't want in terms of care if death is imminent. The advanced medical directive says what I want or don't want for care if I can't express myself, even if I'm going to live for a long time. And then the fourth important component is a HIPAA authorization or a HIPAA release. And that allows the agent, whoever is named in it, to get medical information, but it doesn't necessarily give them authority to make decisions. So in my practice, when we do medical power of attorney, it includes naming the agent, the living will, and the advanced medical directive. And then we do a separate document for the HIPAA release so that the agent can get information even if they don't have to make decisions yet. So if you're going to the pharmacy for somebody, or there was a doctor's appointment and you want to ask a follow-up question, you might be able to do that just using the HIPAA release or the HIPAA authorization, even if the person you're helping doesn't need you to make decisions for them yet. So the medical power of attorney grants authority to make medical decisions. Most states will have a suggested statutory form. It's not required to use that exact form, but something similar is what doctors and healthcare professionals may be more familiar with. In Virginia, we're required to have that document signed by the principal in front of 2 witnesses. In Virginia, it's not required to be notarized, but we typically go ahead and notarize the documents at the same time they're being witnessed, because that might make it easier to use in other states. Whatever a state's requirements are, there's a good chance we've met them. And if you recall, when we talked about the financial power of attorney, we said it could be effective immediately, or it could be springing when we have certifications the person can't make decisions. In Virginia, the medical power of attorney is springing. A person makes their own decision until the doctors determine that they can't give informed consent. And that's when they're going to start looking for decisions from the agent under the medical power of attorney. So the living will, as we said, is part of the suite of documents that are for healthcare decision-making. It generally, in Virginia, it applies when a person is terminally ill and death is imminent, or somebody is in a persistent vegetative state. And as you all know from dealing with people with dementia, that's a very narrow situation in terms of people who need help with decision-making. But that's the living will piece of it, or natural death declaration, only applies for terminally ill with death imminent or persistent vegetative state. It gives instructions the principal wants in terms of what kind of care that they want. Most frequently, we see documents that say, I don't want any heroic or life-prolonging measures. I don't want artificial nutrition or hydration, but I want pain medication. I want to be kept comfortable. But it is important to state wishes for people who do want every intervention possible until the very last minute. It's important to put that in writing. Because if it's not in writing, there's no way for people to know and follow it. So most of the time people are saying what they don't want, but I have had a few people who do want everything that's available. So we need to make sure we write that down. The advanced medical directive is the piece of it that you may deal with more if you're caring for somebody with dementia who's done a more expansive medical power of attorney. And this, if you haven't done this for yourself or you're thinking about updating for yourself, this is where we can really customize things to talk about what treatments people want or don't want. It addresses some of the end of life and afterlife issues, like whether or not somebody wants organ donation. In Virginia, we can include a provision that says my agent can override what I'm telling the doctor if the doctor thinks I can't give informed consent, and my agent thinks in my previous way of thinking that I would want to do what the doctor's recommending. And in Virginia, we can authorize some limited inpatient psychiatric care. We also have the ability to do a separate power of attorney. It doesn't have to be separate, but probably would be, in terms of the kind of psychiatric treatment a person would want or not want. So we do have the ability to do mental health powers of attorney. Some of the specifics on what treatment you can request or decline, what powers you can give or not give, those are going to be state specific. So what I've included here is for Virginia. I get a lot of questions from people about DNRs, do not resuscitate orders, and where those come in. So if you put in place a medical power of attorney, that's not the same thing as having a DNR. And a DNR, having that in place doesn't mean somebody's made all their choices about medical care or appointed an agent. A DNR, a do not resuscitate order, is actually a physician's order. So an individual can put a DNR in place for themselves. They can say, and what that means is, if my heart stops, don't try to start it again. An agent acting under medical power of attorney, unless the document would not allow that, can put a DNR in place. But it's a doctor's order. It comes from the doctor, not from the lawyer. And it's usually specific to CPR and doesn't necessarily preclude something like the use of a ventilator. In some states, they have physician's orders that are called post, physician order for scope of treatment. I think in Maryland, it's post. I don't remember what the L is for. And those, again, come from a physician. They often will include a do not resuscitate order. I have in the slide, it may include a durable DNR. That means not only don't resuscitate, but even if the person's outside of a healthcare setting, if they're not in a hospital or nursing home, can tell the EMTs not to resuscitate. In Virginia, the post orders can be used when the provider would not be surprised if the patient died within a year. So it's somebody who's in a condition that is likely to result in death without a year. It's not used for everybody, and it's put in place by the doctor, either working directly with the patient or with the healthcare agent. Okay, so again, that's been a lot of information thrown at you at once. Let's take a pause and see if we have any questions or discussion on that.
Well, there is only one question in the chat, but I believe you already answered it. But I'll just read it to you. Are post-physician orders for scope of treatment forms the same or different than what you are discussing? And you basically answered that.
Yeah.
And Susan has her hand up. Susan, go ahead.
Yes, is the post the document that notification that it is in the freezer is put on the fridge, a notice is put on the fridge saying this is in the freezer in case emergency workers come in and the person is incapacitated?
So usually I've seen that a post could be done that way. I've seen with the DNRs, though I hadn't seen that the document itself was in the freezer. I have been familiar, the DNRs tend to be on colored paper. I think they might be yellow. And I have seen people keep them either on the refrigerator door or on the inside of their front door or apartment door. But yes, a post would probably be similarly, you'd want that similarly available to emergency personnel. So that if somebody does call in the EMTs, they can see what treatment should not be administered.
Thank you.
In Oregon, they recommended that it be put in the freezer, and they gave you a little magnet that went on the top of, went on the refrigerator that said that there was a post inside
Okay.
on that. And I think the post also was registered with the state, that when you fill it out, it is registered with the state, so they can also look it up from the state.
A lot of, in Virginia, I don't know about the post, if that's got a mandatory registry, the medical power of attorney, there's a healthcare registry that's voluntary and things can be accessed there. It's still, I think it's still helpful to have the paper or the magnet, as they do in Oregon, where somebody's going to see it, because an EMT is not going to stop and look up, or an emergency room doctor is not going to stop and look something up. The healthcare agent, if they're available, is going to be the advocate for what the person wants or doesn't want. But it's important for these things to try to make them, you know, as readily available, the magnet or on the fridge or whatever, so that people do see them. Because if for an emergency care person, unless they are informed that they're not to perform emergency services, that's what they have to do.
Okay, thank you. There are no more questions for now.
Okay, so we're going to go on and talk about wills. So everybody's familiar with wills. People think wills are very important, and I think it's about generally about a third of people who actually get around to doing them. Little bit more, the rate of putting wills in place is higher among people who take care of others and have seen, you know, have experienced what happens after somebody passes away. So the features of a will, what a will does is replaces state laws on intestacy, and intestacy just means not having a will. So every state has a law on its books. If somebody died, where does their real property go? The way it's expressed in Virginia is it says where your real property goes, and then it says and your personal property goes the same way. So what the will does is it replaces that with whatever the person creating a will wants in terms of their disposition. And it replaces the default rules on administering the estate with some preferences of the person creating the will. In putting a will, it doesn't avoid probate. Wills get probated. When putting a will in place, the formalities of signing it are really important. In Virginia, the will needs to be signed between or executed between two witnesses who are in the presence of the person making the will, who's called a testator. These three people all need to be in each other's presence when the will is signed. And then there's, to make it easier to admit the will to probate, there's a self-proving affidavit that says we were all together, and everybody signs that, and then a notary signs off. If we have all those pieces and a person passes away, we can take the will to the probate office, and the clerk there can admit it and get the process rolling. Sometimes those technicalities don't get observed. I have, in some states, they don't have self-proving affidavits. In some attorneys will send the will to the client and let them take it to their local bank or bring in a mobile notary to do the signing. And the difficulty with that is sometimes it doesn't happen right. We usually can still get the will admitted, but it means we have to go before a judge rather than a probate clerk. And that means it costs more, and it takes longer. So getting the details right in the execution is very important. Capacity to make a will is generally thought to be lower than for a power of attorney. And it's essentially that you know who your family is. You, in old terms, know the natural objects of your bounty. You know what your estate is. You've got a pretty good idea of what you own. Maybe not to the penny, but you generally know whether or not you own a house. Do you have retirement accounts? You have a general idea of what you own. And you understand what the impact of making a will be. So again, that's one of the things that as the attorneys, when clients come in and they want to change the will, and even if they have some diminished capacity, we need to be sure that if they're signing something, they know who their family is, they have an idea of what their estate is, and they understand what they're doing when they execute the document. And what a will disposes of are what we sometimes call probate assets. They're the things that a person owns just in their sole name. They have no beneficiary on it and no joint owner of any type. So if the only thing I own is my IRA account and I've named a beneficiary, then when I die, that IRA is going to go to my designated beneficiary and there will be no need to probate my will. If I have a house and I don't have any, my deed doesn't say who's going to get it when I die and it's not joint owned, then that's going to pass through, my will is going to be put into the probate records to pass my house. And if I have bank accounts and investment accounts in my own name with nobody else on them, that's going to be my probate estate. The executor is the person who's carrying out the will. And in Virginia, at least, they are subject to very strict inventory and accounting requirements. So after somebody passes away, if the executor takes office, the inventory's got to list all of the accounts a person has. We don't necessarily have to list all of their stuff, their tangible personal property, unless it's high value, so we don't have to count the socks in the sock drawer. But we do have to itemize all the stocks in the investment account. And we'll have to do an accounting that reconciles every penny that comes into the estate and every penny that goes out. And that's part of the process of probate that people find a little bit sometimes mystifying and generally to be a nuisance. Wills are very, so sometimes when you think about it and you're like, well, I'll just put beneficiaries on all my accounts and I can bypass a will. I can, own things jointly with other people and I won't need a will. That doesn't always work. If the person that you're caring for now is your spouse, you don't want to name them as necessarily as beneficiary and everything if they're not able to manage the assets when you pass. Minors need special care. People under 18 can't, if they inherit, they need, and it doesn't go into some kind of trust for them, they need a guardian of the property to be appointed. People with special needs, people who receive public benefits. So the will is very important in managing distribution to anybody who needs help with money management, creditor protection, or just because of age can't manage their own money. And there are also some administrative provisions that we can deal with through a will to make things a little bit easier or less expensive for an executor than if there were no will and we were just playing under the state rules. Okay, so the people involved in the will, The person who makes the will is called the testator. Sometimes we use testatrix for the woman who makes a will just for fun. The executor is the person who's going to carry out the wishes as they're declared in the will. And again, with any position where we're appointing somebody to do a job, we can have an executor and we can have a backup, which is a good idea. The beneficiary is the person who's going to receive something under the will, who's going to get the distribution of money or property. And then within a will, there may be a trustee. So if you have a beneficiary whose distribution will be delayed, I'm leaving my estate to my 3 children, one of whom's a minor, then I'm going to have a minor's trust, and I'm going to name a trustee and a successor to take care of that young person's share of the estate until they reach an age that I think is appropriate for them to have it outright. So as I mentioned briefly, kind of the informal or alternatives to a will are using joint accounts or beneficiary designations. Joint accounts, of course, frequently people do have shared, particularly married people do have shared accounts. When people are thinking of adding somebody to an account, you do need to keep in mind that your joint owner has the same legal right to access funds during your lifetime as you do. So I'm not going to put as a joint owner somebody who might help themselves to my funds. And as we said before, beneficiary designations are particularly helpful on retirement accounts. They can be problematic for some people. As we said, minors, people who have long-term care needs, people with creditor issues or who are divorcing, people who can't manage money. For those folks, we may be creating a trust either within a will, or if we have a living trust, they might be a beneficiary. So they may still be able to get money, but we don't necessarily want their name on the line on a form if the money's going to dissipate or they won't be able to access it after we pass away. So again, we'll take a little pause. Is there anything we want to talk about with wills?
Hold on just a second. If one of the joint owners of an asset becomes incapacitated, should they be removed from an account? If so, how?
In practical terms, a lot of banks will not remove somebody from an account unless, they might do it with a power of attorney, but sometimes they want the person to remove themselves. It's not necessary for an incapacitated person to be removed from account, and sometimes it's helpful to have a joint owner who's managing that account for them. So if my spouse has advanced dementia and no longer can manage things, but their retirement checks are going into an account that I'm joint on, I can continue to manage things for them. So it can be helpful in that situation. The person doesn't necessarily have to be removed, and in fact, you may not be able to remove them. If there was a reason that the person should not be on the account, such as they're giving the account information out to scammers, then it might be necessary to create a new account, move the funds over to the new account, and just let the old one lie dormant. But the bank may or may not actually let you close the account for somebody else.
Okay, thank you. I don't see anything else.
Okay, so let's talk a little bit about revocable living trusts. So there are lots of kinds of trusts. And so what we're going to focus on for just a few minutes are revocable living trusts. These are the basic trusts that people use primarily for avoiding probate. As we talked about with the will, there's the inventory and accounting in Virginia, it's to an arm of the court called the Commissioner of Accounts. But there are often reasons for privacy or for ease of administration that people want to avoid probate, but doing it by beneficiary designation or joint account is not appropriate. So that's when one of the primary uses for revocable living trusts. So here are the people who are the players in a revocable living trust. And again, different states, you see different terms for these things. So the first person is the one who's going to create the trust and whose money is going to be in the trust while they're living. Their money, their house, and real property usually. And depending on where you are in Virginia, our current code uses the term settlor for that. Our previous code used the term grantor, and in some places you will see trustor. And those all mean the person who's creating the trust. The trustee, that's pretty universal. It's the person who's managing the trust. The beneficiary is the person who receives income and principal from the trust. And the beneficiary may change over time. So initially, when I set up a revocable living trust, I might be the settlor, the trustee, and the beneficiary. During my lifetime, and while I'm able to manage my own affairs, I'm going to be doing all these things, but my trust will have some provisions for what happens after I'm gone. And the capacity to create a trust is the same as to create a will. So I need to have an idea of who my family is, who are the natural objects of my affection, what my estate is, and in making the trust, what that means, what it's going to mean for managing my money during my lifetime and after my death. So to have a trust, to avoid probate using a trust, we actually have to make sure that the things that we own will be part of the trust without getting there through our will. So usually what that means is we do what's called funding the trust, and we title the assets in the name of the trustee. So when I create a trust, I'm going to also prepare a deed that changes, in most cases, that changes title of the home from being held by the individual. So instead of owning my home in my own name, I'm going to own it as trustee of my trust. I'm going to go to the bank and talk with my investment advisors for my non-retirement accounts and have them change the way I hold it. So I'm Loretta, trustee of the Loretta Williams Trust. And that's going to make it easy to transfer control of those assets, or easier to transfer controls of those assets to my successor trustee if I die or if I become incapacitated. So if something happens to me, the person I've named as my successor is going to go to my bank or reach out to the financial institution and say, hey, I'm the trustee, here's the death certificate, here's the doctor's letter showing Loretta can't do this anymore. And they're going to be able to manage things without having to go through the court. When I'm deceased, they're going to step in and manage things and make the distributions without any probate, without any court supervision. So generally, a revocable living trust is useful for people who lose capacity and need somebody else to make their financial decisions. But in Virginia and possibly in some other states, having assets in a living trust might be problematic for Medicaid. And this is talking about a revocable living trust. That varies a lot from state to state, but we've had some situations where I've had clients who already have a living trust. One of the spouses went into a nursing home and we had to move assets out of the trust to facilitate getting the Medicaid. Okay, anything we want to discuss about trust? Otherwise, I'll talk about Medicaid for a few minutes and paying for long-term care.
No, yes, there is one question. For revocable trust, is it easy for the successor trustee to bring a letter from the doctor and be given control, or is there often resistance?
It seems to be easier for successor trustees to do that than for agents under power of attorney. So I will say, when we're planning, when we know that somebody is having diminished capacity and they may at some point not have sufficient capacity, sometimes we'll bring on the trustee sooner. We might bring them on as a co-trustee, so they're already in place. But generally, my clients have had less difficulty as successor trustees than sometimes they have as agents. Sometimes that's because you've gone through the process. You know, the principals, the settlor has gone through the process of setting up the trust. The financial institution may know who to expect to come in. They don't necessarily get the power of attorney in advance of need.
Okay, thank you.
Okay. All right, so let's move on and talk about paying for long-term care in Virginia. Which is a big topic that we'll cover in just a few minutes, but that's okay. So obviously, one of the ways to pay for long-term care is to self-pay. We're fortunate in this area currently that some of our retirees have federal and perhaps even military pensions in addition, and we do have some people who have sufficient income to be able to pay for most of their care. Some people have sufficient income plus savings to cover care for some period of time. To the extent people are cared for at home and with family caregivers, a lot of that care is informal, so it's not being paid for. People who have long-term care insurance, once that gets going, that can be very useful in terms of paying for long-term care for as long as that's in place. Of course, that requires advanced planning. And sometimes with some people, it's not necessarily, the premiums sometimes become unaffordable, but where it's in place, once it's activated, it can be very helpful in terms of taking care of those costs for a number of years. We have continuing care retirement communities. You know, some of the local ones are like Goodwin House or Green Spring. I think the Virginian's still one. And those are places where people move in often as independent living, but often make a large deposit and pay monthly fees with the expectation is that as their care levels increase, they will be able to stay in that community with some control over the costs and to be able to move through levels of care without having to move someplace else. The public pay option, the main public pay option in Virginia is Medicaid. There are some benefits for some low-income veterans that can help defray the costs. The VA Enhanced Pension Program, often called Aid in Attendance, that can be helpful in providing more income for the cost of care, but in a high-cost area that doesn't necessarily cover all the need. So when my clients are looking about how to get help paying for long-term care, often what we're looking at is Medicaid. So let's talk about things we want to know about Medicaid. And again, this is going to be a lot of this is going to be Virginia specific because states are different. So the first thing we want to remember is Medicaid is different from Medicare. Medicare, of course, has your hospital benefits. It's got the physician benefits. It's got the some home health on a limited basis. In terms of nursing home care, it's limited to 100 days of care following a 3-day hospital stay or 3-night hospital stay. Medicaid is a different program. It was originally set up as health insurance for low-income people, but it is one of the largest payers of long-term care and particularly nursing home care in the country. With Medicaid, the rules will vary from state to state. There are some laws, it's both a federal and a state program. So there are some laws and rules that you find the same across the country, but there's some interpretation in how they're carried out state to state. So if you hear something I say about Virginia and your loved one is in Maryland, what I say may or may not be applicable to them because there are some differences. For Medicaid, the care, it can provide care, long-term care to people who are assessed at a nursing home level of care. And so that's one of the things that gets interpreted from state to state. In Virginia, we have a pretty high level of need to be considered nursing home care, but somebody can be assessed at that level of care and be living at home most often when they have somebody, a caregiver also living with them. In Virginia, Medicaid does not pay for assisted living in most cases. The way our system's set up, it pretty much passes that our assisted living residences are licensed differently from our nursing home. And while assisted living could be the best setting, particularly for people with dementia, in most cases, Medicaid does not pay for that level of care. And while it pays for some home care, often there can be exceptions, but often the care is limited to about 56 hours a week, 8 hours a day. The way that plays out in Virginia is it's usually hard for somebody to get care at home if they have cognitive impairment and they don't live with somebody else because they aren't safe to be by themselves, say overnight, and the state's not necessarily providing around the clock care. For Medicaid, there are income limits, and in Virginia, it's basically biased towards nursing home care. If you're in a nursing home and your income is less than the private pay cost of your care, which tends to be around $13,000, so in most cases, the income is less than that, then you can meet the income threshold. Medicaid only considers the income of the person in the nursing home. The spouse's income, if they have a spouse, the spouse's income doesn't count. At home, for in-home services through Medicaid in Virginia, usually a person's income has to be less than about $2,500 a month. And if it's more than that, theoretically, a person can spend down and get Medicaid at home, but it's hard to do that in real life. So under our current system, we do have a bias, unfortunately, towards nursing home care. The asset limit is the same no matter where the person is. And for the Medicaid beneficiary, they can only have $2,000 in countable assets. If a person is married, the spouse can have up to $137,400 in countable assets. Without their spouse being ineligible. And as you might have noticed, there are special rules for married couples in terms of the community spouse's income not counting. At the time of application, the assets of both spouses count. It doesn't matter if we have a financial account that's in one name or the other. My IRA is going to count for my spouse. And so when we do planning for people, for long-term care, this is a lot of what we're doing is we're looking at these rules, how they apply to an individual family's situation, and what we can do to work within them to help facilitate eligibility. You've probably heard of the look back rule. It's 5 years from the date of application. So if a person's in a nursing home or if they're at home and they apply for Medicaid, they're asked if they've made any transfers of any kind of assets in the past 5 years. That includes selling a house, closing one bank account and opening another, anything where you had an asset and you don't have it anymore. And then what happens is it's evaluated to see if the person got fair value back. So if I sold my house and it was worth $500,000, but I sold it to my child for $400,000, I would be deemed by Medicaid to have made a gift of $100,000 to my child. They're going to assess a penalty period based on that gift, and they're going to impose the penalty period for a number of months and days in Virginia, starting from the day I'd otherwise get Medicaid. So when I'm in the nursing home, I've run out of money, and I've applied and been accepted to Medicaid, then they're going to say, oh, well, you gave away $100,000. We're not going to pay for your care for 11 months and some number of days. So they don't, my clients often ask, you know, is Medicaid going to take my house? Are they going to take that account? They're not. They're just going to decide whether or not to pay for your care while you're in a nursing home and don't have the means to pay for it yourself. And that's in Virginia. Some states, they don't take the house, but they do put a lien on it, but we are not a lien state. The home is not a countable asset if a spouse, a minor child, or a disabled child lives in it. So oftentimes we have one spouse who's in a nursing home, or even if they're at home, the home's going to be a protected resource. We have issues sometimes in Virginia with single people either living in a home that's worth more than Medicaid rules for not being counted, or if they move out of the home in Virginia, the house does become countable. And that is different from some other states. It's stricter than some other states. So there's kind of two types of long-term care planning that attorneys do, that elder law attorneys will do. One is advanced planning, and maybe that should be advanced planning. When we're working with people who aren't likely to need Medicaid or help with paying for their care in the next 5 years, we may do some planning that involves some form of gifting or setting up of irrevocable trusts so that they're kind of creating their own safety net, setting aside some resources that would not be visible or accessible to Medicaid after the 5-year look back. A lot of the planning we do is time of need planning. Sometimes it's called crisis planning. And we do it at the point where somebody is about to get or already getting long-term care. It is helpful in doing long-term care planning to do it while there are assets. So rather than waiting to the point, you know, one plan is to spend all your assets until you're gone and then apply for Medicaid if you're in the right place where you can get it. If we start planning at the time that somebody's entering long-term care or it's foreseeable, we may be able to facilitate use of those funds for paying for care, but also for other things that might be helpful and valuable, and make it more kind of a planned entry into Medicaid than simply paying for care until the money's gone. Okay, any questions or comments you guys want to have on Medicaid or long-term care?
Yes. Okay, a couple of questions. If a single person has less than 2,000 in assets, but has Social Security income of $3,000 a month, can they get Medicaid help to cover nursing home costs after spending their own Social Security income?
So if it's nursing home in Virginia, there's rarely an issue of the income being too much. So somebody with $3,000 a month in income who's going into a nursing home would meet the income eligibility. It's very few people, as I said, the private cost of pay is around 13,000 or so a month. And so people with less than that in income generally meet the income requirement. So yes, that person could probably get care.
Okay, thank you. Next one. Is there a legal definition of marriage for Medicare purpose? Same-sex marriage, cohabitation?
So yes, there is, for Medicaid, there is a legal definition of marriage, and that's going to vary state to state. Same-sex marriage is legal in all states. It is valid in all states. So that would be married. Cohabitation or common law marriage is going to vary by state to state. It's recognized in some states. Some states will recognize if you had common law marriage in the state that you kind of came from, they'll still recognize it. But other states, including Virginia, it's not going to be recognized. So that's going to be a state law question.
Okay, thank you. That's it at this point. We have actually 4 minutes to go, literally.
Perfect, because I think we've got 2 slides to go, so we should be able to
Okay.
do that. And the last one has my name on it.
Okay, thank you.
Okay, so what to do next? If you don't have a state, and so we've been talking a lot and thinking a lot in terms of the people we're caring for, please make sure your documents are in place. If you haven't done your own estate planning documents, now is a good time. Remember, we like to plan early or plan now. It's always good to have things in place. And if you do already have your own documents in place, what I always suggest is you pull them out every year. Pick a date that you remember, your birthday, April Fool's Day, whatever, Halloween, whatever day you like. Pull them out and read through them and see if there are any changes in the people you've named to take care of you. Has somebody moved, died, become too busy to help you out, needs help themselves? And if there are any things that might need change, get in touch with the attorney to see, okay, do we need to update this? And unless you're given specific directions, otherwise, it's a good idea to meet with an attorney about every 5 years to review estate planning documents. You know, sometimes we'll see, I've had some wills and trusts lately we've been dating with that were created in the 1980s. And things have changed since then. And some of them would have been helpful had they been updated over time. So if you've got your things in place, that's great. Try to look at them year to year. You know, sometimes we just don't remember what they said. Meet with the attorney about every 5 years. And if you don't have things in place for yourself, it would be a good idea to go ahead and do them. And so that is everything that I had to relay to you all. I don't know if we have.
Okay, we have literally 2 minutes to go. However, Susan is asking you to discuss getting guardianship in that remaining time.
Okay, so guardianship and is done when the planning has not been sufficient for the need. So maybe a person has medical power of attorney, but they're refusing to go to assisted living and they need to. In Virginia, we call it guardianship if we're dealing with personal decisions, conservatorship if we're dealing with the money. It is a court process. It is a somewhat involved process, but it's certainly doable. Usually the first step on guardianship is to talk with an elder law attorney, again, an attorney who does this stuff all the time. So that they can help assess, is it going to be possible to manage things without guardianship or conservatorship? And if not, they can get you through the process. We emphasize the planning a lot because in most cases, if we have the planning, we don't need guardianship, but there can be times when even the best planning isn't enough. Somebody won't get the care that they need, or they've fallen victim to scammers or some other situation where we have to have court intervention to be able to protect them.
Thank you. There is a request can you give us your physical address for the office?
Sure. We're at 10511 Judicial Drive, and that's in Fairfax, Virginia.
Okay.
Yeah, I will send out the information as well as the location for Loretta after class to the people who are attending.
Okay.
One more question. How would I find an elder lawyer because of guardianship and my mother probably needing to go into a facility at some point, and that would be something she will resist?
So
in New York, how would I do that?
So if you can't get a recommendation from somebody you know, and if you want to email me, I may know somebody for you. But the organization I would start with is, the letters are NAELA, National Association of Elder Law Attorneys.org. So it's NAELA, NAELA.org. And they're a voluntary organization that have elder law attorneys throughout the country.
Thank you. NAELA.org.
Correct.
Okay, thank you.
Yeah, the interesting thing is that's how I found Loretta.
Oh, how great is that?
Yeah.
So I used that to find out for an elder law attorney in Fairfax, Virginia, and her name came up.
Yeah.
Okay, thank you so much for such great presentation and very useful information, I'm sure, for many people. Thank you both, Loretta and Bill. And Bill, we'll see you next week.
Thank
Yes.
you.
Next week is the last class, so we will go over placement. And again, thank you very much for attending today. And I want to thank again, especially Loretta, for taking the time to do this. And I know that it's been getting a good response from the class.